ఇట్లనే చాట్ బాక్స్ ఆడుంది చూడండి. చాట్ బాక్స్ వెబినార్ జరిగేటప్పుడు చాట్ బాక్స్ ఉంటది కదా, అది ఒకసారి ఆడుందో చెప్పండి. కనిపిస్తుంది చాట్ బాక్స్.
హలో, గుడ్ ఆఫ్టర్నూన్ శాంతి మేడం. హలో
sir.
Good afternoon sir.
Sir,
can you hear me?
Yes sir.
Sir,
Sir, please turn on your video also, sir. సార్ పెట్టారు. ఓకే సార్, ఓకే సార్.
ఇక్కడ సార్
షేరింగ్ సార్, ఇది మీకు వచ్చేస్తుంది.
స్లైడ్
మురళి వాయిస్ వస్తుందా? మురళి కనిపిస్తుంది స్లైడ్స్
దానికి కదా మరి ఎట్లా దీనికి
మొబైల్
మరి దీనికి అంటే దీనికి ఎట్లా
నెట్ ఆర్డర్ వెబ్సైట్ పెట్టండి.
ఇదిగో అదేనా? ఇప్పుడు ఏది పెట్టడానికి ఫీల్ అవుతుంది? ఇట్లాంటిది ఇంకోటి పెట్టొచ్చా? ఏమ్మా ఇలాంటిది ఇంకోటి పెట్టొచ్చా? సన్నపిన్నిది తీసుకురామ్మా. ఒక్క నిమిషం వస్తాను.
క్యారీ చేస్తారు. బాబు మురళి వాయిస్ వస్తుందా? మురళి ఆ పాట వస్తుందా? ముందు రాలేదు, నువ్వు మాట్లాడు. నాకు రావట్లేదు, మాట్లాడు. ఇప్పుడు వస్తుందా లేదా నీకు? ఇప్పుడు వాయిస్ వస్తుందా లేదా? వాయిస్ వస్తుందా లేదా? నువ్వు మాట్లాడు, నాకు వినపడాలిగా.
శ్రీకాంత్ సార్,
Very good afternoon, friends.
Sir, good afternoon, sir.
Good afternoon to all.
Okay, can you see this screen?
Yeah, yes, sir.
Okay, sir. Thank
Okay,
you.
okay.
The slides ఎట్లా చేంజ్ చేసుకున్నాం జస్ట్ నెక్స్ట్ ఓకే నేను చేస్తాను. ఓకే బాబు థ్యాంక్ యూ
చెప్తా
Or,
అదే Very good afternoon, friends. Today we are going
sir,
to
sir,
discuss.
excuse me, sir. Session not yet started, sir. Just
Sir, can you hear me?
yes, sir, yes, sir. Session not yet started, sir.
Okay. Today we are going to discuss.
Venkaramana, sir.
చెప్పండి సార్.
Sir, session ఇంకా స్టార్ట్ అవ్వలేదు, sir. Just wait for
Okay,
10
okay.
minutes.
ఆడియో ఆఫ్ చేయండి. హలో పంపిస్తాను సార్, ఇప్పుడే పంపిస్తాను.
Yes, yes. Is it audible now? Professor Venkatramana sir, are you there?
Can you hear me?
Yes, sir.
audio?
Yes, sir. Yes. It's audible.
Arif?
Yes, sister, it's audible. Sir? Good afternoon, sir.
And today we are discussing.
Sir,
Madam,
just a minute, sir. Good afternoon and very warm greetings to all the participants present here. The galaxy of intellectuals, distinguished delegates, esteemed academicians, invited guests, and all the participants. I, Dr. N. Vimla Devi, it's my great pleasure as the coordinator of the national webinar to welcome you all to the 7th day of the one-week national webinar come FDP on political institutions and Indian democracy. It's my great privilege to welcome our honorable speaker, Dr. P. Venkatarana, Principal, Government Degree College, Hyderabad. Before we begin this auspicious seventh day session, let's invoke the Almighty God for all His graces and blessings.
Praise Him, you heavens and all that's above. Praise Him, you angels and heavenly hosts. Let the whole earth praise Him. Praise Him, the sun, the moon, and bright shining stars. Praise Him, you heavens and waters and skies. Let the whole earth praise Him. Great in power, great in glory, great in mercy, King of heaven, great in battle, great in wonder, great in Zion, King over all the
Today's session would include the advanced topic regarding the role of judiciary in Indian democracy. This session will provide us the essential knowledge and role of judiciary. I am very much delighted to introduce our today's eminent speaker, Dr. P. Venkataramana, is working as a principal, Government Degree College, Chenchalguda, Hyderabad. Previously, he worked in various degree colleges as assistant professor, an accomplished content developer for Telugu Academy, Government of Telangana. And he writes material for Dr. B.R. Ambedkar Open University and won the hearts of hundreds of students. He is a renowned expert in various fields, identified as a translator by National Translation Mission. Dr. Venkataramana has received the Best Teacher Award by the Government of Telangana in 2018 and has published many articles in national and international journals. He is a man of distinct vision and a fountainhead of illuminating ideas and also living inspiration to the young minds. I am very grateful to you, sir, for accepting our invitation as guest speaker of valedictory session and bestowing us with your presence. I cordially invite Dr. Venkataramana, sir, Government Degree College, Hyderabad, to continue the session. I am sure we will be enriched by your talk. Dear participants, please note, there will be an interactive session. You can interact with our esteemed speaker and clarify your doubts and queries after the presentation. Thank you, and I wish you all the best. Dr. Venkataramana, sir, please continue the session.
Thank you, madam. Thank you for your kind words. The topic is very pertinent and an important one to explore the nature of Indian polity, the role of judiciary in Indian democracy. First of all, let us discuss about democracy. In fact, the very concept of democracy is interpreted with so many meanings and so many interpretations. Some people believe that democracy means providing freedom to the people, providing fundamental rights to the people. Whichever the polity that provides fundamental rights is considered as a democratic country. But that is only partially true. And the other meaning is a democracy is one which provides for periodical elections.
Excuse me, sir.
People have, please share.
Sir,
Hello?
your PPT not visible, sir. Your PPT is not. Okay, sir. Okay. Okay. Okay, sir.
Okay, sir.
Now it's visible, sir. Please continue.
Okay, sir. The role of judiciary in Indian democracy is a very pertinent topic, and today we are going to discuss two important aspects. One is Indian democracy, the other one is the role of judiciary in Indian democracy. If we go to the theoretical meanings of Indian democracy, there are so many meanings associated with democracy. The first meaning is whichever the country that provides freedom and rights is called as a democratic polity. A democratic country is one which provides rights to the people, freedom to the people, and equality to the people. If these three political values are guaranteed, that is considered as a democratic polity. In that sense, India is considered as a democratic country. Indian Constitution provides for the fundamental rights, and with the enjoyment of these rights, we can also have freedom. And among these rights, we also have the right to equality. So equality, liberty, and rights are endowed by the Constitution of India to the people. That's why India is considered as a democratic country. This is the only first meaning. The second meaning of the term democracy is if the country holds periodical elections and people have a right to choose their own government, and if the country enjoys the self-rule, that is considered as a democratic polity. Till 1947, we were under the subjugation of Britishers. Under British colonial rule, India struggled a lot to get independence. But in 1947, we got independence. And after that, India has also wonderfully written its written constitution. And based on the provisions of the constitution and articles, we are governing ourselves. Now we have established a self-rule in India. So that's how periodical elections are held. Some 15 general elections are held in India for the Indian Parliament. And every year we are holding elections for some assembly or some legislative assembly or legislative council or parliament or public local bodies likewise. So that means India is a country with periodical elections. So in the sense that if any country holding periodical elections and provide the right to have the self-government, that is called as a democratic polity. This is the second meaning of the very concept of democracy. The first meaning is the country which provides guarantees for rights, liberty, and equality, that is called democratic country. The second meaning is the country which has periodical elections and which has provided the right to self-governance, self-government, right to elect the government, is also called as democratic government. And the third meaning of the democracy is if the country provides for media freedom, maybe it electronic media or print media, that is called as a democratic polity. In a democratic polity, media freedom is ensured. Media enjoys freedom, and the media has the right to provide the facts and to analyze the facts and to bring awareness among the masses for certain issues of public importance. So this is the third meaning of the very concept of democracy. So this is how democracy is a concept that has various meanings. And in this context, we can also say that democracy provides for decentralization of powers. It is against the centralization of powers. The powers of the government are to be decentralized between central government, state government, and local governments. Wherever the government that provides for decentralization of powers, and involve all the public representatives. That is called as a democracy. And likewise, the fifth category, the fifth concept of democracy is if the polity provides for clear-cut division of powers, separation of powers between legislature, executive, and judiciary, that is also called as democracy. So in this context, we can say that India is a democratic country. So the very word democracy has different meanings and different interpretations. In our own experience, we have seen 5 interpretations. The first one is the country that provides liberty, equality, and justice to the people, rights to the people is called democracy. The second meaning is the country that provides periodical elections is called as democracy. The third meaning is the country that provides media freedom is called as democracy. And the fourth meaning is the country that facilitates division of powers between the central government, state government, and local government, and against to the policy of centralization is called democracy. And lastly, the country is called as democratic if there is clear-cut division of powers between various political institutions such as legislature, executive, and judiciary. So this is also called as democracy. So after knowing these 5 important aspects of democracy, we can see how Indian judiciary enriches democracy in India. In fact, Indian judiciary is renowned as an important institution throughout the world. Not only it is famous in India, but many countries in the world adopt, emulate, and imbibe the spirit of Indian Supreme Court. Indian Supreme Court is the apex court in India, and Indian judiciary is considered as an important political institution in India. So Indian judiciary is endowed with equal powers in relation to legislature and executive. And likewise, Indian Constitution provides the power of judicial review to high courts and Supreme Court. In fact, the power of judicial review is considered to be the propriety of the American Constitution. We all know that the American Supreme Court is endowed with the doctrine of Indian judicial review. The power of judicial review is also given by the Indian Constitution to Indian Supreme Court and Indian High Courts. This power makes the Indian judiciary, particularly the higher judiciary from High Court to Supreme Court. The lower courts do not have the power of judiciary, the power of judicial review. But High Courts and Supreme Court have the power of reviewing the judgments, reviewing the laws passed by the Parliament, reviewing the orders passed by the ministers, the cabinets, the bureaucrats. If they are against the Constitution, the High Courts and Supreme Court have the power to declare them as ultra-virus and against the Constitution. So Indian Constitution provided the power of judicial review to the Indian judiciary, particularly the High Court and Supreme Court. And likewise, judiciary protects the rights of the people and interests of various people, various sections of people. India is a country with various professions, various social groups, various tribal groups. All these groups have their own interests. We have scheduled castes, scheduled tribes, backward castes, minorities, and of course we have various professions in the society, such as the industrialists, agriculturists, employees, and in different age groups of people like women, men, old age people, children, youth, physically challenged people, So different sections of people are there in Indian society, and it protects not only their rights, but it also guarantees their interests. It protects their interests. That's why Indian judiciary got its acclaim throughout the world, that it's a great protector of rights of various sections of people, and it protects the interests of various sections of people. This is another important aspect. And Indian judiciary is free and fair in delivering its justice. It is never faces the problems of fear or anything, and it is very fair and impartial in its judgments. In fact, during the high times of emergency also, there are courts in India that gave judgments against the then ruling party, Congress party, and Srimati Indira Gandhi. That itself is a testimony of how Indian judiciary acts in a very impartial manner. So impartiality is the hallmark of Indian judiciary. All the judgments passed by the Indian Supreme Court are very impartial. They are not influenced by either by the legislature or by the executive or by the judiciary or by any other sections of people. So it fairly, impartially delivers the judgments. That's why Indian judiciary is respected and honored throughout the world. In this context, I should also mention that some of the Indian Supreme Court judges have also become the judges of International Court of Justice. The judges of International Court of Justice, Justice Nagendra Singh, Justice P.N. Bhagavati, these are the judges who are not only headed the Supreme Court in India, but also they acted as judges of International Court of Justice. So that means their impartiality, their fairness brought them the gubernatorial positions, and they become judges at the global level. So that's how Indian Supreme Court is very fair and impartial in its judgments. This is another important aspect. Now let us see. The structure and constitutional provisions of Indian judiciary. As we all know, the Indian judiciary is a monolithic structure. Supreme Court at the apex level, High Court at the state level. We have behind that there's district level courts, city civil courts, and various other courts throughout the India. So that means it's a monolithic structure. With Supreme Court is at the apex level. The higher the court that is, the higher the responsibility in its delivery of judgments. So Indian Supreme Court carries the highest regard, and the judgments of Indian Supreme Court are carried out with high respect throughout the country. So Indian judiciary consisted of many courts at various levels, right from village level, mandal level, district level, state level, and the national level. There are different types of courts and different levels of courts. And at the micro level, we have the village level courts, and mandal level courts, and of course the district level courts. These courts are there. And at the state level, we have high courts. In India, almost every state has high courts. And a group of states, so for example, the northeastern states, as a group have a court, High Court of Guwahati, likewise. So there are high courts at the state level, and some of the states unitedly have a high court. And at the national level, we have a Supreme Court. And Supreme Court is considered as the apex court, where the Constitution bench always interprets the provisions of the Constitution. The interpretation of the Constitution is given by the apex level court or the Supreme Court. So, Indian judiciary is not just one court or two courts. It's a monolithic structure with hundreds of courts. There are hundreds of courts right from the micro level to the macro level. Among them, the Supreme Court is considered to be the apex level court or the highest level court. That is called as the Supreme Court. And behind that, there are state level courts. They are called as high courts. And behind high courts, there are district level courts. District is the jurisdiction for their delivery of justice. And behind them, there are civil courts, criminal courts at various levels. And of course, there are also some village level courts also. So this is how Indian judiciary consisted of hundreds of judges, hundreds of courts at different levels, in which the Supreme Court of India is at the apex level. So Indian Supreme Court has certain important provisions. The Indian Constitution in Article 124 to 147, it describes the powers and functions of the Indian Supreme Court. It gives a vivid description of various powers of the Indian Supreme Court. Indian Supreme Court consisted of nearly 30 to 35 judges. The number of judges also varies according to the parliamentary laws. At the time of its institution, it has only 7 judges. Later, the number is increased to 18. Later, it is increased to 25. Presently, we have 33 to 35 judges are there. And one of these judges of Supreme Court is called as the Chief Justice of India. We have Y.V. Chandrachud. Y.V. Chandrachud is the Chief Justice of India. So, Indian Supreme Court is an apex court, and the powers and functions of Indian Supreme Court were meticulously described by the Constitution. Article 124 to Article 147 of the Constitution provides for the vivid description of Indian Supreme Court, the powers of the Indian Supreme Court. Article 124, Article 125, Article 126, Article 127, likewise Article 147. All these articles have described the composition, powers and functions of Indian Supreme Court. And no other court in the world is as vividly described as the Indian Supreme Court powers. The American Supreme Court also has its own powers and functions. But that those powers are not as totally and comprehensively described as the powers of the Indian Supreme Court. That is a greatness. In fact, Dr. B.R. Ambedkar, he himself is a legal luminary. He has completed his studies in Columbia University of America, and he has later enrolled himself as a doctoral student in London School of Economics and Bonn and various other universities. And he has obtained his law degree, and he himself is a legal luminary. He has studied many constitutions of the world. In fact, Dr. B.R. Ambedkar, as a legal luminary, he knows the necessities and niceties of the Indian situation, and he has compiled beautiful provisions for the Indian Supreme Court. That's why, while writing about the powers and functions of the Indian Supreme Court, he has chalked out Article 124 to Article 147 in describing various provisions of the Indian Supreme Court. So this is how the powers of the Indian Supreme Court were wonderfully described. In fact, he has also laid down the qualifications for becoming a Supreme Court judge. The qualifications are also very meticulously described. Common people cannot become the judges of Supreme Court. It requires a special qualification, experience in a legal profession, 10 years of experience as an advocate, a lawyer at the High Court level, and at least 5 years of experience as a judge of a High Court, or the research and innovative teaching techniques in the legal profession. So people who acquire these qualifications are only qualified to be the judges of Indian Supreme Court. No other constitution in the world, no wonder they describe the provisions of appointment as meticulously as Indian Constitution. Indian Supreme Court has very comprehensively and totally, very vividly described the powers of the Indian Supreme Court from 124, Article 124 to Article 147 of the Indian Constitution. After that, while discussing the state government, the Indian Constitution has described the powers of the high courts, Indian high courts. Indian high courts are the courts that are constituted at the state level to render justice. And Article 214 of the Constitution to Article 232 of the Constitution, it describes the powers of the high courts. In fact, the poor people cannot afford to have justice directly at the Supreme Court. That's why the Indian Constitution provides for approaching various courts at the local level, at the district level, at the state level. If any litigant do not find justice at these levels, he can approach the Supreme Court. That's why Article 214 to Article 232 of the Constitution describes the powers of high courts. In fact, every high court has its own jurisdiction and it can interpret the laws passed by the state legislature in various state governments. Even high courts also have the power of judicial review. They can question, they can challenge, they can even make a trial on the constitutional validity of various laws passed by the state legislature. If any state legislature passes a law that is ultra-virus to the Constitution, it can declare it as an unconstitutional. Even the Supreme Court has the power to declare any law as unconstitutional. So the power of judicial review is not only just limited to the Indian Supreme Court, but that power is extended even to the high courts also. So that is the beauty of Indian Constitution. As I have told you in the beginning, Indian Constitution is meticulously written by various legal luminaries. Among them, Dr. B.R. Ambedkar is one of the distinguished personality. Besides being a social activist, he is a legal luminary. Dr. B.R. Ambedkar, he himself championed the cause of scheduled castes, scheduled tribes, backward castes and minorities, and of course women's rights. And besides being a social activist, he himself is a legal luminary. He has studied almost all the provisions of all the constitutions of the world. And Dr. B.R. Ambedkar has meticulously added Article 214 to Article 232 in the Indian Constitution as the powers of Indian High Courts. Constitutionally speaking, every state should have a High Court. But based on the geography of the state and based on the population, the density of population, certain states do not have High Court of their own, but a group of states have a High Court, like the northeastern states, Manipur, Sikkim, Meghalaya, Assam. All these states have a High Court. That's called the High Court of Guwahati. So, all in all, the concept of High Court is considered to be a very valuable one. And if the population of the state is very high, every state has an autonomous High Court by itself. And if the population of the area, the state, is relatively less. The density of the population is very relatively less. A group of states have a high court. So this is how Article 214 to Article 232 of the Constitution describes the powers of various high courts. And Indian Constitution also specifies the number of judges in a high court. According to the provisions of Indian Constitution, the number of high court judges vary from one court to another court. If the geographical area or the density of population is more to a particular state, it has the number of judges is more. If the density of population and geographical area of the state is less, it has less number of judges in the high court. So the number of judges in a high court is diametrically related and inversely proportional to the number of people living in the state and the extent of geographical area of that particular area. So this is how the number of high court judges is decided according to Article 214 and Article 232 of the Constitution. And likewise, Indian Constitution also describes about the powers and functions of subordinate courts. The courts just below the level of high court are called as subordinate courts. There are a number of courts like district courts, municipal courts, magistrate courts, village level courts. There are various different courts at the local level. The Constitution has meticulously described the powers of these courts under Article 232 to 233 to 237. Article 233 to Article 237 of the Constitution describes about the powers of the subordinate courts. And these subordinate courts are very approachable to the people because a district level court is more accessible to the common people than a high court and a Supreme Court. That's why these courts are called as subordinate courts. And these subordinate courts respect the judgments of high courts and Supreme Court. While delivering a judgment by these courts, they quote the judgments of High Court and Supreme Court. So that's why the upper courts are considered of the court of records, and the lower courts, they take the judgments of the upper courts in delivering the judgments. Likewise, Article 233 to Article 237 of the Constitution describes the powers of the subordinate courts. Now let us see what are the powers of Indian Supreme Court in a nutshell. Article 131 of the Constitution provides for original jurisdiction. This original jurisdiction includes the disputes between central government and state government. As we all know, there are 28 state governments in India. And if there is a dispute between central government and state government, it is the responsibility of the Supreme Court to resolve the dispute. In fact, Supreme Court acts as an arbitrator between the central government and state government in resolving the disputes. That's why it is called as the original jurisdiction. The original jurisdiction of the Supreme Court in Article 131 of the Constitution, it protects the federal nature of Indian Constitution. The federal nature of Indian Constitution is protected by the Indian Supreme Court through Article 131 of the Constitution. Article 131 lays down the provisions for the resolution of disputes between central government and one state government, between the central government and a group of state governments, between one state government and other state governments, between one group of state governments and other group of state governments, between the state governments of North India and the state governments of South India, the state governments of one particular area and the state governments of other particular area. If there is any dispute among these units, it is the responsibility of the state Supreme Court to resolve the dispute. This is called as the original jurisdiction. And after that, the Indian Supreme Court also have appellate jurisdiction, appellate jurisdiction, appellate jurisdiction, and advisory jurisdiction. Appellate jurisdiction means common people have the power to appeal, to make an appeal in the Supreme Court. There are civil appeals and criminal appeals. There are civil cases and criminal cases. All these cases are to be heard by the Supreme Court, and Supreme Court delivers its judgment. Article 132 and Article 133, Article 134 provides the people to appeal to the Supreme Court in demanding justice. Likewise, Article 143 of the Constitution provides for jurisdiction, advisory jurisdiction of Supreme Court. If there is any dispute that cannot be resolved by the government, the President of India can refer the issue to the Supreme Court. That is called advisory jurisdiction. The Supreme Court can give its advice to the government. The President of India can make an appeal to the Supreme Court for advice. In such a case, the Supreme Court renders its advice to the state government and central government. That is called as the advisory jurisdiction of Indian Supreme Court. And likewise, Article 129 of the Constitution provides for the power of the Supreme Court to record the judgments. That's why it is called as the Court of Records. The Court of Records. The Court of Records means the judgments of the Supreme Court are to be recorded, and all the lower level courts will follow the judgments, these records. And if the nature of a criminal activity or a civil case is same, many courts can take the Supreme Court judgment as an example, and they render same type of judgments in all the cases. That's why Indian Supreme Court is considered as a court of records under Article 129 of the Constitution. In fact, the judgments of Indian Supreme Court are followed by many courts, not only in India, but also in third world countries, European countries, and various parts of other countries, various parts of the world also. Indian Supreme Court is considered to be an international court, and its judgments are valued, and they are often quoted by other courts throughout the world. So that's why it is called as a court of records. And Indian Supreme Court protects the rights of the people, the fundamental rights of the people. In fact, Part 3 of the Constitution provides for the protection of fundamental rights of the people. All the fundamental rights of the people given in from Article 12 to Article 35 of the Constitution in Part 3 of the Constitution are to be protected by the state. It is the responsibility of the Supreme Court and High Court, judiciary, to protect the rights of the people. Protection of fundamental rights is the fundamental duty of the Supreme Court. By using its power, the Supreme Court given many judgments which enforce the fundamental rights of the people. When the governments infringe the rights of the people, violate the rights of the people, it is the Supreme Court and it is some of the high courts that came forward and protected the rights of the people. There are many cases, many examples for this. Even during the times of emergency, some of the rights of the people are protected. So this is how the protection of fundamental rights is the duty of the Indian Supreme Court. And likewise, as I have told you in the beginning itself, Indian Supreme Court has the power of judicial review. That means the judiciary can review the laws passed by the parliament, the orders passed by the Prime Minister and his cabinet, whether they are in tune with the Constitution or not. If they are against the Constitution, it can declare them as unconstitutional. So the power of judicial review given to the Indian Supreme Court gives additional power to the Supreme Court to examine the laws passed by the Indian Parliament. If they are according to the Indian Constitution, it okays it, it approves it. If they are against the provisions of the Indian Constitution, it can declare the law as null and void. It can declare the law as unconstitutional. So the power of examining the laws passed by the legislature, the orders given by the executive, is called as the power of judicial review. As I have told you in the beginning itself, the power of judicial review is given only to the Supreme Court of America. The American Supreme Court enjoys this. Later, this power is endowed to the Indian Supreme Court also. So this is an important power. And likewise, Indian Supreme Court is the final interpreter of the Constitution. It interprets the Constitution. In fact, the provisions of the Constitution are to be given new meaning to new changed situations, newly changed social conditions and economic conditions. So in all these changing conditions, new meanings are to be given to the Constitution. So likewise, it interprets, it gives new meaning to the provisions of the Constitution. So that's why Indian Supreme Court is considered as the final interpreter of the Constitution. It finally interprets the Constitution. It gives new meaning to the provisions of the Constitution. Of course, the provisions of the Constitution were written 75 years back, in 1950, that the Constitution came into force. The provisions were written between 1946 to 1950. Whether the provisions that are written 75 years back are valid today or not, and Supreme Court make it valid by giving new meaning, new interpretation to the provisions of the Constitution. That's how it's a final interpreter of the Constitution. Of course, the Indian Supreme Court also has other powers. The judges of Indian Supreme Court acts as chairman in inquiry commissions, and they also act as magistrates in various burning issues. This is how the Indian Supreme Court has so many powers. If we could relate these powers to the Indian democracy, we can say 4 or 5 things. One is, Indian Supreme Court protect the rights of the people. It's a protector of fundamental rights of the people. Secondly, Indian Supreme Court interpret the Constitution in the changing circumstances. And Indian Supreme Court resolves the disputes between central government and state government. So this is how Indian Supreme Court has many powers in the context of Indian democracy. Now let us see what are the drawbacks of Indian Supreme Court and Indian judiciary. Indian Supreme Court has its powers, of course. There are so many powers. But why people are not getting justice? There are millions of cases pending in the Supreme Court. There are many jokes. There are many comments. There is a lot of criticism against the functioning of Supreme Court. If we approach for justice to Supreme Court, you are sure of getting justice after 3 decades or 4 decades. That means in Indian Supreme Court, justice is delayed. The delayed justice. Justice delayed is justice denied. Justice delayed is justice denied. This is a provision, this is a proverb in English literature. Justice delayed is justice denied. If you cannot render justice on time, it amounts to say that justice is denied. You are doing injustice. So this proverb correctly applies to the Indian Supreme Court. Indian Supreme Court has only 33 to 35 judges, but they have to deal millions of cases that come across its functioning. In a vast country as wide as India, there are so many cases. Everybody wants to approach Supreme Court directly. Some people take special leave petitions and approach the Supreme Court. So that's how there are millions of cases pending with the Supreme Court. So that's why, is it the quality or quantity? Quality of justice is good, but in quantitative terms, delayed justice is there. Justice is delayed. What could be the reason? Because if we compare to European countries, in European countries, for every 1 million population, there are 10 judges. That means for every 1 lakh population, there is a judge. But in India, for every 50 lakhs people, there is only one judge. That means the proportion of judges to the population is disastrously low in India. In India, sufficient judges are not there, sufficient number of judges are not there. Once the judge is retired, his post may be filled after so many decades. There is no regular appointments to the posts of justices in various courts. So all these reasons delay the justice. As a result, there is delayed justice. Justice is delayed. Justice delayed means justice denied. If we approach the court today, you may get justice after 10 years or 20 years or 30 years. There are people who get justice after 50 years. What is the fun of it? When you cannot get justice instantaneously, it amounts to injustice. This is one drawback of the Indian judiciary. The second one is, Indian judiciary emphasizes only on the procedural aspects of justice. It cannot many times discuss the substantial elements of justice. The substantial elements and procedural aspects. Only it gives substantial hearing, but it follows procedures. The procedures of the Indian Supreme Court are very complex. As a result, these procedures only deny the justice in Indian context. So, Indian Supreme Court gives more importance to procedures than the substantial aspects of justice. The procedural aspects and substantial aspects are the two different types, and it gives more importance and more emphasis on the procedural aspects more than substantial aspects. It gives more substantial aspects if the judgments are more substantial, then the quality of justice is good. But it concentrates more on the procedural aspects of justice. And the other one is judicial accountability and judicial standards. It is proven that many of the judges are corrupt. At the lower level, if you want to get a bail or if you want to get justice at the lower court, there is a lot of criticism that even money also makes its influence on the judgments. That means there is less judicial accountability at the lower level, and the judicial standards at the lower level are disastrously low. The lower level courts can be influenced by the higher echelons of power, political leaders, bureaucrats, influential people, money-made people, industrialists, entrepreneurs. Those with money can even buy justice. That is the irony of the thing. So there is hardly any judicial accountability at the lower level. There is no supervision. There is no sufficient transparency in the judicial process at the lower level. As a result, the judicial standards are also falling at the lower level. This is another thing. And as I discussed earlier, there are structural deficiencies. The structural deficiencies are related to the number of judges, the number of courts, likewise. In this context, I'll give you an example. There is a lot of demands. There is a long pending demand by the people of South India that there should be a Supreme Court bench in South India. But Supreme Court is only there in Delhi. The Indian Supreme Court doesn't want a bench in the South India. As a result, many cases related to South India are pending with the Supreme Court for the last so many years, and some of the people do not have access even to the Supreme Court benches at the North Indian courts, Supreme Court at North India. So that's why even in high courts also, there are various demands for high court benches in various parts of the state. So concentrating a court at only one place denies the chances of providing justice to the people of all the areas. And as I've told you in the beginning, the ratio between judges and litigants is also very high in India. For every 50 lakh people, there is only one judge. But in developed countries like Western countries, for every 1 million population, there are 10 judges. So this is also a kind of a structural deficiency in India. And if you take the system of punishments, the Indian system of punishments based on three theories. One is eye to eye theory. If a person takes away the eye of a person, the judgment is also to take the eye of the other person. It's called eye of eye theory. And this is a medieval theory. A judgment or a system of punishment should be transformative in nature. The transformation aspect of punishment is missing in the Indian system of punishment. Take, for example, the capital punishment, death penalty or hanging penalty. Once a criminal is hanged, you cannot expect any behavioral changes in him. If you want a behavioral changes in a criminal, if you want a criminal to become a human being, leaving his criminality, the system of punishment should be changed. The system of punishment followed by the Indian Supreme Court or the judiciary in India sometimes appear to be uncivilized. Do they really match the values of civil standards, civilian societies, civil societies of contemporary societies? So this is another important aspect. And likewise, in India, for every crime, for every defect, we approach a court. But in other countries, it's not like that. For every stream, there is a different type of justice. Suppose there is a defect or a criminality in education sector should have a court. If there is a wrong thing or a criminality in a transport sector should have a court. Likewise, if there is any criminality or wrongdoing in taxation, all the tax department should have a judiciary. So that means every department should have a judiciary of its own. if you do not have alternative forms of justice, all people go to Supreme Court only. All people approach high courts only. So this is not fair. This is overburdening the judiciary. The judiciary is overburdened with these things. So that's why there must be alternative forms of justice. If you do not have the alternative forms of justice, then the burden of the judiciary may be increased anyfold. That's why alternative forms of justice is to be encouraged. Of course, in tune with this, the Indian government is also introducing the family courts, the transport courts, the mobile courts, and likewise the gram panchayats, the tribal panchayats, to resolve the disputes at the local level. In fact, there is a local panchayat. That panchayat should be given powers to settle the disputes among the offenses of the local people, because the place of the crime is very much nearer to the place of judgment. That's why alternative forms of justice are required in any society. So that's how Indian judiciary plays a very important role. And in this context, I can give you some of the examples, like the Indian Supreme Court has rendered the Keshavananda Bharati case, the Maneka Gandhi case, and in Mandal Commission case also, it has given judgments. So these are the judgments, and ADM Jabalpur case. So these are the cases that have really protected the rights of the people. If the judiciary cannot protect the rights of the people, the judiciary is meaningless. So unless the political value of justice is provided, democracy has no meaning. That's why democracy acquires its meaning only it provides meaningful justice to the people. In fact, in societies like India, judiciary also plays a major role in the policy formation, policy implementation, and policy evaluation. Excuse me, friends. There are so many policies like the agriculture policy, industrial policy, environmental policy, education policy, policy of exports and imports, foreign policy. These are various policies. Right from the beginning, the policy formulation stage to policy implementation, policy evaluation, judiciary plays a very important role. For example, in the policy formation, if we take the right to education guaranteed in Article 21A, the Supreme Court has many times chided the government and criticized the government for not providing a right to education to the children below the age of 14 years. After so many criticisms, the Indian government has come forward and made it a fundamental right. That means it is the criticism of the judiciary that paves the way for the interpretation of policy and need for policy formation. So the policy formulation is provided. Some components of policy formulation are provided by Indian judiciary. Likewise, the environmental policy. Many a time, the central government, state government, and various local bodies were criticized by the judiciary for environmental pollution and environmental degradation. As a result, the Indian government came out with a policy of its environment policy. So that means when a substantial criticism on various tendencies are made by judiciary through its judgments that lead to the policy formation. And this policy formulation is also, it is meticulously observed by the Indian Supreme Court and supervised by Indian Supreme Court. So the policy implementation part is also observed by the Indian Supreme Court. So policy formation, policy implementation, and policy evaluation. In fact, policy implementation is the duty of the executive. Policy formulation is the duty of legislature. And policy evaluation is the duty of the researchers. But all the three duties are done by Indian Supreme Court. Indian Supreme Court, it provides inputs for the policy formulation. It also provides inputs for policy implementation. If any of the government department is not adequately implementing any different policy, judiciary makes it and asks the department to change its methods of implementation, and it provides a new method of implementation for it. So that's how policy implementation is there. And likewise, policy evaluation. The successes and failures or drawbacks of a policy are evaluated by the Indian Supreme Court. For example, rehabilitation and resettlement policy of the government. Whenever the land acquisition is done by the government from the poor people, all the poor people are to be resettled and evacuated to a safer place, and resettlement is to be done. And resettlement policies of the government are evaluated by the government, by the Supreme Court. And as a result of the interference of the Indian Supreme Court, the rehabilitation and resettlement of the land acquisition policy is evaluated and a new system is implemented by the government. So whenever the Supreme Court intervenes and evaluates a public policy, then the government suddenly wakes up and it comes out in addressing the problems of the people. So that's why judiciary not only protects the rights of the people, but it also formulates the policies. It intervenes in the implementation part of the policy, and it also makes an evaluation, an objective evaluation of the policy, whether it is beneficial to the people or to the inconvenience of the people. So policy formulation, policy implementation, and policy evaluation are meticulously done by the Indian judiciary. And this enhances the role of judiciary in enriching the Indian democratic polity. This is what. And judiciary is an important instrument in providing socio-economic justice to the people. Justice has three dimensions: the political justice, economic justice, and social justice. As we all know, India is a country with many social groups. Caste is the main dominant social group. There are hundreds of castes, thousands of castes, some of the upper castes, some of the middle castes, some of the lower castes. And still we see the social evils like untouchability prevailing in some of the areas, and the lower classes are oppressed by the upper classes. In all such cases, the lower classes are frightened, are fearful, even to represent their problem to any section of civil society. Then the judiciary comes forward and addresses the social problems of the people. And likewise, Indian economic situation is also quite interesting. Indian society has three economic groups: the middle classes, the lower classes, and the upper classes. The middle classes wants to become upper classes, and the lower classes wants to become middle classes. And the problem of poverty pushes them to people into unemployment and poverty. And these problems makes the Indian society into three economic groups. upper classes, middle classes, and lower classes. In all such cases, the taxation system is evolved in accordance with the nature of the Indian economic situation. So whenever any of these three sections find injustice in matters of taxation or in matters of economic benefit, the judiciary readily interferes. With the intervention of judiciary only, the Indian economic situation is brightened. So Indian judiciary plays a very vital role in providing social justice and economic justice to the people. Here again, we have to recollect ourselves the role of Dr. B.R. Ambedkar. The B.R. Ambedkar is considered as a champion of social justice, has prescribed a very constructive role to the Indian judiciary, and he has included Article 32 of the Constitution. With Article 32 of the Constitution, every citizen of India has a right to approach the court, right to constitutional remedies. If there is any problem, if an ordinary citizen is facing, Article 32 guarantees a remedy to be given by the judiciary to the ordinary people. So thereby, Dr. B.R. Ambedkar envisioned many problems that the lower classes, lower middle classes, scheduled castes, scheduled tribes, other backward castes, minorities and women in the Indian society. Because these are the sections who are oppressed for the last 2 or 3 millenniums, and these sections are facing the problem of injustice, the social injustice, the economic injustice. Of course, there is no political injustice. There is political injustice right from the beginning. So, in all these cases of social, economic, and political injustice, it is only the judiciary that stands as a ray of hope. Without judiciary, the society cannot be transformed. So, the concept of equality remains as a dream. So, equality is to be realized. Social justice, economic justice, and political justice should be guaranteed to the citizen of India. It is the judiciary, it is the intervention of judiciary, it is the powers of the judiciary, it is the initiative of the judiciary, it is the constitutional provisions of judiciary that provides the social justice, the economic justice, and political justice to the people. If there is no judiciary, there is no democracy, because there is no justice, there is no equality. Even normal living by lower caste people, the lower level, lower classes people will also become a distant dream. That's why judiciary is engaged in social justice, economic justice, and political justice to the people. Judiciary is an important organ of the Indian political system. All the three institutions of Indian polity, such as the Indian Parliament, Indian Executive, and Indian Judiciary, make the judiciary a meaningful instrument, and it is only the judiciary that enriches the Indian democracy. Of course, legislature is there, parliament is there, legislative assemblies are there, local self-governments are there, people exercise their votes for every 5 years. But what is the use? They have made all the Indian democracy a mockery. The problems of the common people and lower class people are not at all addressed for the last 7-8 decades. And likewise, the executive, it becomes very dictatorial, and it is encroaching upon the powers of judiciary and legislature also. And Prime Minister has become so powerful, and at the state level, Chief Minister has become so powerful. But the powers and functions of the Prime Minister and Chief Minister are meticulously supervised by the Indian judiciary. If the Indian judiciary cannot supervise the powers of the executive, you cannot assume that Indian society can become a democratic society. So, for the survival of Indian democracy, for the enrichment of Indian democracy, for the civilizational nature of Indian democracy, for the protection of people's rights to enrich Indian democracy, and for fighting the centralized tendencies of certain governments against the wishes of the people, judiciary is very much required. If judiciary is not given powers, then you'll have only dictatorial form of government. You'll have only a government that threatens the people and the government that makes the laws to the detrimental of the interests of the lower classes and other classes of the people. Indian democracy may be enjoyed only by certain sections of the people. It cannot become universal. Thanks to the interventions of judiciary, Indian democracy becomes universal. It is applicable, it is enjoyable, it is practiced, it is enjoyed, it is applied to all the sections of people. Only because the judiciary is transparent, the judiciary is meaningful, the judiciary is intervening in different levels of the powers of the government. Had the judiciary not been given these powers, Indian democracy would only remain a mockery. That's why, for the survival of Indian democracy, for the enrichment of Indian democracy, for the empowerment of all the sections of people in Indian democracy, the judiciary should be given more powers. The judiciary should be endowed with various important aspects of intervention. Of course, Indian judiciary intervenes in different instruments. No other country in the world has instruments like public interest litigation, judicial activism, writ issuing power, the power of issuing the writs, habeas corpus, mandamus, quo warranto, certiorari, prohibition. These are the writs that are provided in Article 226 of the Constitution, Article 32 of the Constitution, Article 134 of the Constitution, are clearly implemented by the courts. By implementing these instruments only, Indian Supreme Court is expanding its horizons of power, and it is intervening into the areas of legislature and executive and protecting the rights of the people. If there is no such institutions like Indian judiciary, the rights of the people may become a myth. So, for the survival of democracy, for the protection of the rights of the people, and for the protection of the interests of different sections of people, Indian judiciary need to have more powers, and Indian judiciary should be endowed with more and more powers. Thanks to the initiatives of the present government, of course, central government and state government, the judges of Supreme Court and High Courts are appointed on regular basis, and now our judiciary is very active, and as I have told you, it is acquiring the international acclaim because the judgments delivered by Indian Supreme Court and High Courts are very respectfully recorded by various courts of the world. And some of the judges of Indian Supreme Court are taken as judges of International Court of Justice after their retirement. And the Indian Supreme Court judges after their retirement are also becoming the chairman of various committees: National Human Rights Commission, National Women's Commission, National Scheduled Caste Commission, National Scheduled Tribes Commission, National Other Backward Caste Commission, National Minorities Commission. So these are the commissions. They are working under the shadow of, under the blessings of the legal luminaries. And not only that in India, but these judges are also going abroad, and they are rendering service as advisors to the judiciaries of various countries. And more importantly, the judges of Indian Supreme Court or become the judges of International Court of Justice, The Hague. So this is how Indian judiciary is playing a very vital role in protecting the democracy and in enriching the democratic values of the society, and the civilizational values of Indian society are enriched only with the expanding horizon of Indian Supreme Court, Indian judiciary. Thank you, friends. Thank you very much. I invite any questions or queries from the audience. Can you hear me? Hello?
Yes, sir. It's audible. Kala Battula Ramakrishna, sir, raised his hand. Please clarify your doubt, sir. Ramakrishna, sir.
Thank you for your comment, Sujata madam.
Good evening, sir.
Please tell me.
Yes, please, ma'am.
Good evening, sir.
Very good evening.
Sir, what's your take on judicial activism and judicial overreach? Is Indian judiciary going overboard and encroaching upon the powers of executive and legislature, or is it just doing enough to provide socio-economic justice to the people of India?
That's really a very good question. In fact, there is a lot of criticism on the working patterns of Indian judiciary, and Indian judiciary has a habit of interfering in some of the powers of the legislature and executive, but it appears to be overreaching, but in fact it is not. Sometimes that much of interference is required for the protection of the rights of the people. Unless that intervention is not there, other institutions like legislature and judiciary may have their heyday, and they may even suppress the rights of the people in the name of progressive legislations and orders. So there should be a check. Indian judiciary is making a check. May it be called as a Indian judicial activism, or may it be known as a overreach, but whatever the term it may be called. But that kind of overreach is warranted because such a society with a huge diversity, to protect the rights of the people and to protect the interests of diverse sections of the people, that type of overreach is very much needed. Thank you for your question. It's the question is very meaningful.
Thank you so much, sir.
Ramakrishna ji, T. Ramakrishna garu.
Ramakrishna sir. Please clarify your doubt, sir.
Friends, I have come to this lecture with a lot of hope that a good number of questions will come and my thesis will be countered by all the people. But to my utter disappointment, only a few people have come forward. Of course, I am thankful to you all.
Hope there is no further questions. Then we will proceed. Thank you, sir, for your outstanding presentation.
Thank you, Madam Garu.
An impressive talk on role of judiciary in Indian democracy. You have enlightened us in detail about the structure and the constitutional provisions, the powers of and functions of the Supreme Court, High Courts, and subordinate courts, and also drawbacks of Indian judiciary. It was really an enriching session. We are really grateful to you to share your valuable thoughts and insights with us. Thank you once again, sir, for making today's session very effective and successful.
Thank you, Madam Garu.
Thank you, sir. Then we will proceed to the valedictory session of expressing gratitude for the fruitful one-week webinar come FDP on political institutions and Indian democracy. I cordially welcome Dr. Sister Shaini KP, Principal, all the dignitaries, honorable speakers, and participants to the valedictory ceremony. It's my proud privilege to welcome Dr. Sister Shaini KP, Principal of JMJ College for Women, to deliver the valedictory address.
Good evening, everyone.
Good evening, sister.
It is an honor to address you all today on the final day of our national webinar come FDP on political institutions and Indian democracy from 6th to 12th October 2023. I would like to express my heartfelt gratitude to all our esteemed speakers who have shared their expertise and enriched the participants with their knowledge and wisdom. I thank very specially Dr. G. Koteshwara Prasad, Professor, Department of Politics and Public Administration, University of Madras, Chennai, for his continuous assistance and guidance. I very specially thank all the participants who have faithfully engaged in the webinar. Political institutions plays a pivotal role in shaping our societies and governance systems. It's the foundation for informed decisions, critical thinking, and effective citizenship. I encourage each of you to continue exploring the new knowledge through online and offline forums, seminars, and conferences. I would like to express my gratitude to the organizing convener, Mrs. C.H. Visrandama, Head of the Department of Political Science, the coordinator of the webinar, Dr. N. Vimla Devi, and all other moderators for their contribution and efforts to make this seminar a grand success. I sincerely thank Mr. Murali and Mr. Srikanth for their invaluable technical support in facilitating the successful conduct of this online webinar over the past 7 days. Once again, I thank today's speaker for his lively presentation and a very informative session. As we leave this online platform, we go with optimism that the knowledge and insights gained from this webinar will lead us to a more informed future. Once again, I thank you all for your valuable support and contribution. Thank you. May God bless you.
Thank you, sister, for your motivational and inspiring valedictory address. And then, coming to mark the national webinar come FDP, I request Mrs. C.H. Vishrantama, convener of the webinar, to brief the report.
Good afternoon to one and all. I am very glad to present a report of 1 week national webinar come FDP, organized by Department of Political Science on Political Institutions and Indian Democracy. From 6th October to 12th October 2023 through Google Meet. The webinar was attended by 400. The webinar has structures with an inaugural address by Dr. Shaini, Principal. Dr. Nimla Devi, coordinator of the webinar, welcomed all the designators and the participants. The ceremony was commenced with prayer. Professor P.V. Muralidhar delivered a take entitled India at the rate of 75, raising and working of the political institutions. He discussed on the topic Parliament, Legislature, Executive and Judiciary, and also Election Commission. He focused mainly on federal structure and decentralization. And Dr. E. Venkateshu collaborated in political and various public policies in post-independent India. He exclusively discussed on political institutions dealing with power. He also enlightened a new education policy on different types of Indian caste system. Dr. P. Murthy, Senior Professor, Pondicherry University. He spoke on Indian democracy today, self-help and social reforms perspective. He discussed about the developing countries are with negligible poverty and illiteracy. Dr. G. Veerraju, head of the political science, Andhra University, mentioned the significance of Indian democracy and role of parliament in Indian politics. He discussed about parliamentary powers and functions and division of powers in central and state government. Dr. Nanjareddy, professor in political science and public administration, has briefly explained the importance of an evolution of computing consumption of Indian nationhood. He enlightened about modern state evolution, civic identity, rule of law, colonial period and post-colonial period. Professor G. Koteswar Prasad explained the female political leadership in state and also Indian democratic experience. He explained about female education and said about different countries, presidents, prime ministers and state chief ministers. He said there is a highest female participation in Renado country in legislature and women reservation bill passed in Indian Parliament. Dr. P. Venkatramana, Principal of Government Degree College, Hyderabad, has deeply expressed on role of judiciary in Indian democracy. He enlightened about democracy, five aspects: liberty, equality, periodical elections, media freedom, and decentralization of powers, separation of powers, and also Indian Supreme Court and High Court powers and functions. The faculty appreciated the information shared and showed a keen interest to know more detailed information on specific topics. Overall, the webinar was a huge success from of the point of view awareness building about the political institution and Indian democracy. Thank you, one and all the participants.
Thank you, ma'am, for your wonderful report. Honorable dignitaries, distinguished guests, esteemed speakers, participants, colleagues, and my friends. I am glad to propose vote of thanks and acknowledge the contribution of those who work really hard to make this 1 week national webinar come FDP. On behalf of the JMJ College for Women and the entire fraternity of the institution, as coordinator of the webinar, I extend my sincere thanks to the Almighty for making magnificent success. I should first thank and convey my deep regards to our honorable eminent speakers, Dr. B.V. Muralidhar, SV University, Tirupati, Dr. E. Venkatesh, University of Hyderabad, Dr. P. Murthy, Dean and Senior Professor, Pondicherry University, Dr. G. Veerraju, Andhra University, Dr. V. Anji Reddy from Acharya Nagarjuna University, Professor K. Koteshwar Prasad, University of Madras, Dr. P. Venkataramana from Hyderabad, who spare time from their busy schedule to grace this 1 week FDP with their extremely relevant address. We have no words to offer gratitude for your motivation and inspiring talks. We are ever grateful to you for your impressive and lively sessions. Your interaction with the participants was really outstanding. Once again, we are very much grateful to all the respected speakers for sharing your rich knowledge and valuable suggestions. Thank you once again to all the masters of teachers. I render my sincere thanks to Dr. Sister Teresa, correspondent, for always encouraging us and providing opportunities to organize such events. My sincere gratitude goes to Dr. Sister Shiny, KP Principal, JMJ College for Women, for being a constant motivator and a guiding force in all our endeavors to excel in the field of education. I am ever grateful to Sister Sarada, Dr. Sister Amal for your cooperation and support. You have always been generous with us. Thank you, sisters. My deep sense of thanks and appreciation to Mrs. C.H. Vishrantama, convener of this 1 week webinar. Thank you so much, ma'am, for your excellent cooperation, commitment, and meticulous care. I would like to extend my heartfelt thanks to the organizing committee, my colleagues and my friends, Dr. G. Jyoti Olivia, Dr. Amal, Mrs. P. Arunodaya, Mrs. C.H. Anuja, for your relentless efforts and being with us in making this webinar a grand success. My special thanks to the wonderful participants who chose to believe with us and attended the webinar with great enthusiasm and made it successful. We had a great time having you all. Last but surely not the least, I convey my sincere thanks to Mr. P. Murali and Mr. Srikanth for all the technical support and for helping us to webcast our sessions. Once again, a big thank you to each one of you wholeheartedly for glorifying this 1 week FDP with your gracious presence. To conclude, I wish you all a great success in your pursuits. Now, I would like to wind up the program with a few announcements to the participants. Feedback form will be sent to your registered mail ID within 2 hours. All those who have attended and filled the feedback form will be receiving the e-certificate very soon. Have a wonderful evening. Thank you, one and all.